Hello.
Hi.
Hi, who am I speaking to?
Hi. My name is Edresh Ali.
Okay, I will put you back in the waiting room, and when the judge calls your case, we'll bring you back in, okay?
Thank you very much.
You bet. Hello,
Hello, this is Leonardo.
Leonardo. What's your last name?
Brias.
I'm going to put you back in the waiting room, and when the judge calls your case, we'll bring you back in, okay?
Okay.
Madam Clerk,
Yes,
what's going on right now?
waiting for our prosecutor.
Okay,
I've messaged him and Chris is contacting the office, so hopefully he'll be here soon.
okay. I don't have anything to do with these cases. I just, I didn't know.
I just called his office and he said he was running late and he was just logging on. So I think he got caught off guard.
Hold him in contempt, Judge.
I apologize for not having a tie and a shirt on. This one kind of snuck up on me. I didn't catch it on my calendar this morning.
I thought you didn't have to.
Shirt on? That's what I gotta say. I did actually have a defendant show up in Quinault Court without a shirt.
Oh, that's nice.
It was,
Did he have like a jacket on but no shirt?
no.
Oh, that's almost worse.
Yeah. The jacket would be, a hint of formality.
I'm here, and I'm sorry for running late. I basically hit every stoplight I could trying to get back to the office.
So for Judge Bates, we have in the waiting room, Molly Stiegel and Ed Taylor. Is there a preference on which case you want to hear first?
Doesn't matter to me. I'll let the parties decide which case they want to call.
Why don't you call Mr. Taylor first, because I'm looking for a document to send Mr. Duncanson.
All right, is this Mr. Taylor?
Present.
All right, this is Judge Pro Tem Chris Bates. Here today we have the city prosecutor and also your defense attorney. And
He's pro se. Sorry.
Oh, it comes on pro se, sorry. And Mr. Taylor, Mr. Duncanson, how are we proceeding today?
Did I understand you to say that I was appointed an attorney?
No, that was my mistake. The court clerk corrected me. You are representing yourself.
Okay. Well, and who is the prosecutor this time? Because it has changed, I think.
And his name is Killian Duncanson.
Okay. Well, due to the fact that I haven't had a chance to have a sit down or a phone conversation with him, I'd like to ask for a postponement till I can do that.
Okay, this number that you're calling in on, is that a good number he can reach you at?
Yes, Your Honor.
Okay, Mr. Duncanson, can you take down Mr. Taylor's phone number so you can make contact with him and he can
Yes, I
contact?
can. And I will also let Mr. Taylor know that I did have a Jason Villasina from the Northwest Justice Project contact me as well regarding his case. So
Okay. So that's I understand and appreciate that, and so I'm good to go with the postponement if everyone else is.
Okay, do the parties think that a month?
But I am pleading not guilty. Excuse me, Your Honor. My plea is still not guilty, but would appreciate if I could get some time to sit down with the prosecutor.
Sure.
I think I can get this resolved without it having to go to court.
And I think we'll set this case over a month. And what will that court date be, Madam Clerk?
July 28th.
Okay, so we will send you notice. We will be back on July 28th, and hopefully the two of you will have had a chance to communicate.
Well, I appreciate the professional courtesy and everything else very much.
You're welcome. And that concludes your hearing for today, Mr. Taylor. You're free to log off.
Thank you. Goodbye.
Ready for Ms. Stiegel?
Sure.
Okay.
All right. Is Molly Stiegel present on the other line?
Yes.
Ms. Stiegel, this is Judge Pro Tem Chris Bates. And
Hi.
Mr. Quittner, are you Ms. Stiegel's attorney?
Yes.
Your defense attorney is here along with the prosecutor. And this is a pretrial conference today, meaning the court is checking to see where the case is, what the status is, if it's going to be resolved, or if this is a case that needs to be set on our trial calendar.
That's correct, Your Honor. It should be set on the trial calendar. There's no resolution short of that. I don't think for us, short of dismissal, that is. So I don't believe we have a trial date. We set one.
What do our trial dates look like, Madam Clerk?
The earliest one we could do would be August 17th. It's Tuesday, and we usually have them around 9 a.m.
That's free for me.
Okay, I've already, you must have gotten me these dates in advance because I do have that reserved in my calendar. So if we do a jury trial setting, and Mr. Quittner, this is a jury trial, not a bench trial, correct?
Correct.
Okay. If we set this on for jury trial August 17th and have a jury confirmation in July, does that give the parties enough time? Is discovery completed?
Yeah, there's not a lot of, I mean, from my end, there's not a lot of discovery to be had. And if there's more, Mr. Duncanson and I will surely exchange it by well in advance of the trial date.
Okay.
I don't anticipate any more discovery on my end. So.
And the August 17th date works for everybody?
Yes.
Yes.
Well, the case will be set August 17th. We will have jury confirmation in July. Madam Clerk, does that give you enough time to get notice out to potential jurors?
If we can have that on the 14th, the first hearing date, then that will give me plenty of time.
Okay, so we will set jury confirmation July 14th with a trial date of August 17th. Ms. Stiegel, any questions? It sounds like this is queued up for trial.
No, if I have any questions, I'll talk to my lawyer.
That's the spirit.
Smart move.
Yeah.
Okay. That concludes your hearing today, Ms. Stiegel. You can go ahead and log off.
All right, thank you.
Okay.
And that's all I have on for Judge Bates.
Okay, I appreciate it, and we'll see everyone next month.
Thank you. Judge Benoyer, are you ready?
All right. Are we ready to get going on my stuff?
Yes.
My apologies to everybody. I was under the impression that there was a few more cases that Mr. Bates had to handle.
There were, but they are not logged on. So
All right. Well, what do we got hanging here?
if we could do Mr. Ali's case, we have Mr. Hatch in the waiting room.
Okay. Madam Clerk,
Yes.
it doesn't look like we're making any headway here.
I'm getting ready to message him. See what's going on. There he is.
Mr. Hatch, can you hear me?
Now he should be able to.
All right. Mr. Hatch, can you hear me okay? Not yet.
Says he's he's connected.
Mr. Hatch?
Good morning, Your Honor.
Good afternoon, Mr. Hatch.
Well, yeah, I guess you're correct on that.
Well,
So-
no, it's not a matter of that.
This is one of those days I think it's going to feel like morning all day.
I appreciate that, Mr. Hatch. We all
Have you
have
had
days
those
like
days?
that. So we are on the record here for City of South Bend versus Edrish Ali, cause number C21-6752. I'm Will Penoyer, judge for the City of South Bend Municipal Court. We've got David Hatch, attorney for the defendant on the record, Killian Duncanson, prosecutor, and I see a unnamed phone number here that I presume to be Mr. Ali.
Yes.
See,
Okay,
yes, that is Mr. Idris Ali, Your Honor.
wonderful. If the parties could edify me as to the status of the case.
Judge, what's going on? There's two parts of this case. This is the allegation is sale of minors. There's license going on. My esteemed colleague is handling the matter for Ali, and I've spoken with him as they've been going on, and we had a phone conference this morning. And so what I'd like to do at our case today is simply request that we have a pretrial conference set in July. There should be a waiver on file good through September 30th of this year.
Mr. Duncanson,
I have no objection to that.
then I don't see any reason why that's an issue.
Okay.
So we are setting it for which day in July?
Yeah, what is the court dates?
We have the 14th and the 28th.
14th and 28th? Hang on just a second. Let's, oh boy, I'm gonna have to look at something very fast, excuse me.
Sure.
Let's go ahead and set it on the 28th. I have a trial set on the 14th. Okay, that's all I have, Your Honor.
Okay, it sounds like that's all we have for this case for today. So thank you, Mr. Hatch. Thank you, Mr. Ali. And we will be back on, I didn't even hear the date, but either way, I'll be here.
7/28.
Okay.
Great, July 28th.
Thank you. All right, thank you, Mr. Duncanson.
Go on, Mr. Hatch.
Mr. Whitner, do you have a preference?
Not really. Ms. Kianaper and Mr. Minks are definitely both ready to go.
Okay. Ms. Kianapour was in the waiting room first, so we'll take her.
Okay, we are on the record. Will Penoyer, judge for the City of South Bend. We are on the case of City of South Bend versus Nazida Kianpur.
Yes.
And Mr. John Whitner is representing Ms. Kianpur. Killian Duncanson as prosecutor on the record. Ms. Kianpur is here on the record as well. I received some papers in my email an order amending the DWLS 3 charge to NVOL second, which is an infraction. And I also received an order of dismissal of a attached speeding ticket. I assume that's accurate, as to what the parties wish to do?
Yeah, there's what we had agreed, Your Honor, yes.
Okay. And Ms. Kiana, you're aware of this?
Yes.
Okay. So as I read this, this would mean that you are admitting to the infraction of no valid operator's license with identification.
Yes.
So you admit that that was committed.
Yes.
Okay. The fine amount was left blank on my end. Is there an agreement on the fine?
I thought it was $150. I left it for Mr. Duncan to confirm.
Yeah, I just didn't see that it was blank. Yes, it was $150.
Great. I'm going to write that in then, $150. I'm going to find that the infraction was committed and impose a fine of $150. And I guess obviously I'm going to amend the charge to NVOL second on cause number C216784. I'm also going to dismiss I-21-27306, which is the speeding infraction. And does that take care of everything, you gentlemen?
As
Yes,
long as Ms. Kiana is aware that DWLS is driving with license suspended and NVOL means no valid operator's license.
Ms. Kiana, did you understand that?
I'm sorry, my mom started talking. No, I didn't hear that last part.
Okay, and we have a habit of talking quickly and using acronyms. Sometimes that can be confusing. What it amounts to is that we are amending the criminal charge of driving without a license, third degree, to an infraction that's non-criminal, which is no valid operator's license with identification. So
Okay.
that's what you're admitting to, and I'm dismissing the speeding ticket.
Okay, yes.
Okay, I understood you. We were fine with that. I'm fine with the 150 fine. So we are all good on that. Any other issues?
No, Your Honor.
Okay, Ms. Kiana, you'll receive information in the mail on how to make those payments, and you can go ahead and take care of that.
Awesome. Thank you.
Great, thank you, and thanks to the parties for getting this worked out.
Am I dismissed?
Yes.
Okay,
Sorry, I
thank
thought it
you.
was implied. My apologies.
Sorry, you're good. Thank you.
No, I understand your caution. Have a good day.
Okay, we'll bring in Mr. Minks this time.
All right, Mr. Minks, can you hear me okay? Mr. Minks, can you hear me? Okay, he appears to be on mute or can't hear me.
He's not on mute.
Then I can't hear him.
He probably needs to connect to the audio.
Mr. Minks? Can you hear me? Okay. You need to connect to the audio. He's not going to be able to read my lips, but.
Lisa, can you send him a chat? I may as well ask if the court has received his signed pleadings in this case.
No. Which of you sent them to me or would send them to me?
It would have gone to the court. I talked to Mr. Minks today. We had reached a resolution that was agreed between Mr. Duncanson and I discussed them with Mr. Minks, and he signed them, or he told me he signed them and put them in the mail to the court. He did not say when.
Okay.
And I,
Madam Clerk, have you received those?
I have nothing.
Okay. All right. Well, I don't know that I mean, he can't hear us anyway, so I don't really want to get into it any more than that. We'll wait until he can connect.
and Jamie, my my assistant's telling me that I have the signed ones and I need to forward them to Kelly. So I will do that now. My mistake. But we still can't hear Mr. Minks, so we have a second.
Okay. Do we have anybody else waiting?
Yes, we have our arraignments and a contested.
Okay, well, while those guys are working on those, can we do the contested?
Sure.
Well, this doesn't seem to be working either. How close are you guys?
Oh, they should have gone through to Mr. Duncanson by now.
I am signing them now.
Okay. Then I assume he'll forward them to me.
Mm-hmm.
Okay. Well, I suppose, I guess since Miss Dupea doesn't seem to be working right now, I guess we can go back to, what was that case? Minks. Is Mr. Minks there? Well, I'm not hearing anything here. And Mr. Duncanson, are you forwarding that email to me?
Yes, I just did.
Okay. Okay. I guess we should move on to something else. I don't want to just sit here. So I guess we should try Ms. DePaya again, and then if that doesn't work, we'll move on to the arraignments. Thank you. And I'm keeping watch for that email from Mr. Duncanson. It hasn't showed up yet, but sometimes there's a little delay. Okay. This is Will Penoyer. Is there, can you hear me, Ms. DePaya? This is South Bend Municipal Court. Calling Teresa DePaya. All right, well, that's the second time at it that we haven't had any success. And I do not see an email yet arriving from Mr. Duncanson. So I guess we will move on to the arraignments, if that's all right, Madam Clerk.
Absolutely. We have Mr. Bareilles.
Okay.
Hello.
Good afternoon. This is Will Penoyer, judge for the city of South Bend Municipal Court. And is this Leonardo Bareilles?
Yes.
Am I pronouncing that right? Is it Bareilles?
Yeah, Bareilles.
Bareilles. Okay.
Yeah.
Mr. Bareilles, we are on today for arraignment in your case. What that means is that's your first appearance in for a criminal charge. You are charged in our court with no valid operator's license without identification. NVOL1 is the short term for it. That's cause number C21-6826. And you've also got a infraction for driving without insurance, which is I-21-27383. And this all was alleged to have occurred on June 3rd, 2021. This is your first appearance today, so we're going to go through your arraignment, Mr. Bareilles, and then talk to you about whether or not you want to get an attorney appointed. Okay?
Okay.
All right. Can you hear me okay so far?
Excuse me?
Are you able to hear me okay so far?
Yeah.
Great. Thank you. All right. So as I said, this is you're on for arraignment for the charge of NVOL first. This is a standard misdemeanor, meaning the maximum penalty is 90 days in jail or $1,000 fine. That's not what you're necessarily going to get in this case. That's just the maximum you can get in this case. You have the following rights: the right to remain silent. That means you don't have to say anything about this case to anybody now or in the future. You have the right to be defended by a lawyer and have a lawyer present at all hearings. If you cannot afford an attorney, one will be appointed to you at public expense. You have the right to a speedy trial within 90 days of today, which is the date that you would enter a not guilty plea. You have the right to have your guilt decided by a jury. A jury trial begins with you being presumed innocent, and the judge will tell the jury they're to consider you innocent until the prosecuting attorney can prove the case beyond a reasonable doubt. You have the right to be present at trial, to question witnesses, and to challenge any evidence presented against you, and also to call you can have witnesses called on your behalf at no expense to you. At trial, you can testify if you wish, or you can remain silent. And if you do remain silent, the judge would instruct the jury to not hold that against you. If you're found guilty at trial, you can appeal the question of guilt to an appeals court. However, if you do plead guilty in this case, your rights to appeal are very limited. Do you have any questions about those rights so far?
I have a question. I don't understand too much English. So you know how somebody speaks Spanish there?
Not today.
Okay, I'm sorry. I wish you'd said that at the start, sir. We certainly don't want to arraign you if you don't understand what we're saying. We don't have a Spanish interpreter today because we did not realize that you needed one. So,
but it's okay.
Certainly we will take care of that. That's a right you have. So, Mr. Brias, if you have no objection, what I guess we'll do is continue this case until the next date's July 14th, correct, Madam Clerk?
Correct.
So we're going to set this over for July 14th. And
Okay.
we will make sure that we have an interpreter here so that to assist you with understanding, okay?
Okay, but I live in Chehalis, but I don't know if I can change the court here.
No, the court has to be here.
Okay.
So you will have to be here on July 14th.
July 14th?
Yes.
Okay.
And sir, do you understand? I mean, do you understand any of what do you understand much of what I'm saying?
Yeah, I understand. It's
What
fine.
I'm wondering is if I should appoint you an attorney at this time. That way we have already taken care of that. Would you
Okay.
like to have an attorney appointed to represent you?
No.
Okay. Well, that's an important question, and I'm not going to dispose of that if there is any language barriers at all. So at this point, Mr. Brias, we're just going to set this over for July 14th. You can be here. Let's see, what time do we have people appear in person? 12:45, 12:30?
Correct. 12:45.
12:45 here in South Bend. And we'll make sure to have an interpreter available, okay?
I understand, but a little bit. So I don't have nobody to go there.
You mean you don't have a ride to get here?
Yeah.
Okay, I'll tell you what, Mr. Brias, we'll let you appear for this next hearing through the Zoom, okay?
Okay.
Like you're doing today, but we'll have an interpreter, okay?
Okay.
All right, so 12, what are we telling people on Zoom? Is it 12:30 or 12:45?
If they log on at 12:30, then I can get them identified.
Okay, 12:30, July 14th, log on here, okay?
Okay. So I'll be there to July 14th?
Yes, on the Zoom, on the video here,
Okay.
okay?
Okay. Sound good.
Okay. All right, we'll see you on the 14th. Thank you, sir.
Right.
Okay, and try Mr. L. He's also on for arraignment.
Okay.
Hello? Hello?
Hello, Mr. L, can you hear us okay?
Yeah, now I can. I was trying to figure out this thing. It's kind of... Yeah, I can hear you perfectly fine.
Okay, great. Mr. L, my name is Will Penoyer. I'm the judge for the city of South Bend. And we have you on today for arraignment for a charge of driving while license suspended 3rd degree. That's cause number C21-6827. What I'm going to do today is read you through your rights, and I'm going to see if you need to have an attorney appointed for you. Okay?
Yes, sir.
Great. The first thing I will say before I go on is that I did read the police reports, and I did find that there's probable cause for the case to go forward. That does not mean that I found you guilty. It just means that there's enough information for the case to move forward. You're charged with DWLS 3rd, driving while license suspended 3rd degree. That's a standard misdemeanor. That means that the maximum penalty you can face in this case is 90 days in jail and a $1,000 fine. That's not likely what you'll get. That's just the maximum that you can get under this charge.
Yes, sir.
So we're going to go through your rights at this point. At this charge, driving while license suspended 3rd degree, you have the right to remain silent. You don't have to say anything about this case now or at any point in the future. You have the right to be defended by a lawyer. If you cannot afford an attorney, one will be appointed for you at court expense. You have the right to a speedy trial within 90 days of when you enter a not guilty plea, which is likely today. You have the right to have your guilt decided by a jury. The jury would be instructed to presume that you are innocent unless your guilt would be proven beyond a reasonable doubt. You have the right to be silent at trial, but you can also speak at trial if you wish. You have the right to be present when evidence is being presented to the jury so that you can see, hear, and question the witnesses called against you. You have the right to have witnesses called on your behalf and not at your expense. And if you're found guilty at trial, you can appeal the question of guilt to the next court. However, if you plead guilty, most of your appeal rights are limited at that point. Do you understand your rights so far, sir?
Yes, sir.
Okay. Were you planning on hiring an attorney, or would you like the court to consider appointing one for you?
Rather have the court appoint me one.
Okay. Can you, what is your monthly income?
Right now I'm currently disabled because I have a broken foot.
Okay.
I just got out of Harborview like about a week ago on my
Oh,
second.
no. I'm sorry to hear that.
Before we go any further, I just checked Mr. L's driving abstract, and he is relicensed.
Oh, okay.
So I would offer to amend it to the infraction no valid operator's license with ID for $180 if he'd be willing to take that today and be done with this.
Yes, sir.
Okay, Mr. L, did you understand that?
Yes, sir. I believe something about my license.
Well, Mr. L, what he's proposing is that he says that you've obtained your license. And so because of that, he's willing to amend the charge from a criminal charge to an infraction with a fine of $180.
Oh, okay.
So you have the choice of accepting that, or we can appoint an attorney and you can come back at another time.
I will accept what other sir said.
Okay. Mr. L, I want to be clear, I'm not targeting you with this question, but I do have to ask, since you just had surgery, you're not under the influence of any narcotics that are clouding your judgment in any way?
No, sir.
And I had surgery myself relatively recently, and I know how that can be. Wasn't meant as any kind of dig at you. I've just got to make sure people understand what's going on in court, okay?
Yeah, I completely understand. Yeah.
I have every reason to think that you do, sir. Okay, great. I thank you for answering that. And so, Mr. L, what we would do then is, if you would admit that you committed the infraction of no valid operator's license in the 2nd degree, that's an infraction. I would amend the charge to that and impose a fine of $180. Is that what you want to do?
Yes, sir.
Okay, so you admit that that particular infraction was committed?
Yes, sir.
Okay.
I was wrong.
All right, then I'm going to find that it was committed. I will amend the charge to that infraction, and I'll impose a fine of $180. The information on how to make payments will be mailed to you, Mr. L. Do you have any questions for me?
No, sir.
Mr. Duncanson, is there anything I missed?
Nope, I just forwarded an order, so.
Okay. Great. Well, Mr. L, I appreciate your participation in court, and I'm glad you got your license, and have a great day.
All right, thank you, sir.
And thank you, Mr. Duncanson.
Can we try and bring Minks back in? I need to run to Superior Court.
That's fine.
Can you hear me?
Yes, Mr. Minks, I can hear you. Can you hear me?
I can.
Wonderful. Okay, this is Will Penoyer on the record for the case of City of South Bend versus Michael Minks, cause number C196706, and I think we have another one too, C196705. My understanding is that the parties have reached an agreement in this case. We're on for pretrial today. I've got a statement of defendant on plea of guilty and a judgment and sentence, along with an order of, looks like it's dismissing one of the charges.
Two of the charges, actually, Your Honor, and I want to put that out there to make sure that me and Mr. Duncan are on the same page about it. I believe there were 2 leash violations that are each being dismissed, and 1 count of theft that he's pleading to.
Yeah, and in anticipation of the plea, city so moves to dismiss the 2 the leash violations.
Okay. The order I received dismissal has cause number 6705 and 6706 on it. I don't think that you mean 6706 because that's the one for theft 3, right?
Yeah, it should only be the 705.
Does that sound right to you, Mr. Quittner?
I will double check it. To my mind, it was on 6706, there were 2 different charges listed, but I can
No, 6705 has 2 leash violations.
Got it.
Which I understand you're dismissing, and 6706 is a theft 3, which I understand we have a plea.
Okay, yeah.
Is that accurate?
That is.
Okay. So, Mr. Minks, is that what you understood was happening?
I do.
Okay. All right. Well, in that case, I'm gonna go through the bureaucratic stuff now. Go through your statement of defendant on plea of guilty and your judgment and sentence. So bear with the court here.
Okay.
First off, your name is Michael Edward Minks. You're 51 years old. What level of school did you finish, sir?
7th grade.
Okay. Thank you. And you've reviewed these documents, the statement of defendant, judgment and sentence?
Yes.
Okay, great. And at this time, you are entering a plea of guilty to the charge of theft in the 3rd degree, correct?
Yes.
Right. And it looks like the parties have agreed on a $300 fine. Are there any restitution issues in this case?
No, we specifically would have not agreed to restitution for reasons I won't go into. So no, we didn't discuss restitution.
Mr. Duncanson?
Off the top of my head, I don't recall.
I just,
restitution was.
before I go through this, I want to make sure we're on the same page.
I don't specifically recall.
I don't know what Mr. Minks is alleged to have stolen, so.
Yeah, I don't specifically recall remembering to see any restitution amounts in the discovery.
Oh, it's theft of services.
Yeah.
Yeah, it was water, and we definitely have Mr. Minks does admit to hooking his water back up, but he does not admit to the amount that the city suggested that he took. So the restitution issue if there were one, would hang us up.
Okay, it sounds like Mr. Duncanson is not seeking restitution. Is that accurate?
Yeah, I'd say at the most, I don't recall seeing an amount or anything regarding restitution from the city. But maybe just reserve it, and if we need to have a hearing on it, we can.
Okay, well, I will just tell the parties for the record that there's a city, the record says that there was a total bill of $209.88. So I guess I want to clarify, if I reserve on that issue, does Mr. Mink still want to go through with pleading guilty today?
No.
Okay.
Yeah, let me talk to Mr. Quitner about that. It might be something we let go, and I'll talk to the city as well, and we'll have a resolution.
Okay, Mr. Minks, do you understand what's going on here?
I do.
It sounds like the parties had an agreement, but in being detail oriented, it seems I threw a monkey wrench into that agreement, but I'm sure the parties can work out. So I'm going to give you guys until the 14th of July to figure that out, okay? Mr. Minks?
Yes, okay.
Okay, because I don't want you to be pleading guilty to something that you did not agree to.
It was 3.5 gallons. I was just testing to see if they hooked up my
Mike,
end.
don't talk about the facts, please.
I'm not going to use that against Mr. Minks or hold that against him, but yeah, Mr. Minks, don't make any statements about the case on the record. You have that right.
Okay.
Thank you. All right, so we'll be back on the 14th, and hopefully we'll have this all wrapped up by then, okay?
Okay.
All right, thank you, Mr. Minks. And I guess both the attorneys are good to go now?
Yeah, we are.
All right, thanks, guys.
Thank you.
Thanks.
Okay, do you want to try Ms. DePia?
Sure.
Excuse me.
Am I done?
You are. You can hang up.
Yes, thanks, Mr. Minks. Have a good day.
You too. Bye-bye. I can figure it out. Let's see. Back to maybe, no.
Man, these squares are so big now. Or rectangles, rather. Okay. Ms. DePea? Okay, this is City of South Bend versus Teresa DePea. Ms. DePea is not present on the record. There's a Zoom that is connected. I can see a background of a home and it says Teresa. So it seems that the party's Zoom is connected, but the individual is not there. Normally, if someone did not appear for a contested hearing, I would simply, oh, good, Ms. DePea is here. I'm wondering if maybe she didn't hear me because the sound wasn't connected, you know?
It says it is on our end.
Okay.
She might have her speakers turned off. I don't know.
Do you mind sending her a message?
Thank you.
Thank you, Madam Clerk.
Mhm.
Oh, that's encouraging.
Oh my gosh.
Well, I hear you now.
Sorry.
No need to apologize, ma'am. I just can't conduct court if you can't hear us.
Sorry. Okay, I got it now. I was like, yeah, I got it.
Okay, great. Well, I'm glad that that's the case. We are on the record for cause number 1A0370693, Teresa Marie Dupea, it's a speeding ticket. The allegation is that you were speeding 10 miles per hour over the limit. I have you down here that you wish to contest this infraction, which means that you deny that you committed the infraction. The other option that people have is a mitigation hearing where they admit they committed the infraction but are asking for a break on it. So which of the two are you?
Well, I guess I should have picked mitigation. I don't know why.
That's why I usually tell people that, is because that's often the case.
Yeah, I mean, I don't think I was going that fast, but
That's fine.
yeah.
So what you're saying is you admit that the infraction occurred, but you would ask the court to consider some mitigating factors.
Yes.
All right. Why don't you? I've read it, so go ahead.
Well, I think I just passed the sign for the speed limit change, so I don't know. I feel like I slowed down, but I don't think I was going, because it just changed to 40. I did see the sign, and I felt like, well, he was in an unmarked truck, and I came around a corner, and I don't know. I didn't slow down enough, I guess.
Okay. Anything else?
No.
Okay. Well, that's easy enough. And ma'am, I did look at the ticket, and it says that you were pulled over at Quincy Street, which I can speak from local geography that is just past the 40-mile-per-hour sign. So what you're stating is accurate, and I was going to count that in your favor. So and you've also got a good record. This is the only speeding ticket that shows up on your Washington record. So
Yeah.
have you ever done a deferral before? I guess I should mention that too.
Well, I haven't had a ticket in a long time, so what's a deferral? I don't really know exactly.
So every 7 years, you're allowed a deferral, which just means that you pay the amount of the ticket, but if you stay out of trouble for the year after you pay the ticket, it's dismissed at the end. You're allowed to do that once every 7 years in Washington.
Okay. I mean, I kind of thought that's what it meant, but so is this it'll be on my record for a year? Is that what you're saying?
If you did a deferral, it would be on your record for a year and then dismissed at the end.
Okay.
Or I would
not
I would reduce the fine to $95. Those are your choices.
With the deferral, you would not have it. It would not get reported to the Department of Licensing.
Oh, my apologies. I was under the impression it would show up. So no, it wouldn't be reported to the DOL unless you violated it within the year.
Okay, so pay the full 140.
139, yeah.
And have it, or 139, and defer
for a year.
Yeah.
Or 95.
But it doesn't go on it doesn't get reported right now. Okay. Okay. I mean, I'm pretty careful driver. I don't, but that's fine. Yes. Let's do that. I'll just pay the 140 and deferral.
139, but I know that sounds really nitpicky, but if we couldn't cash the check if it was 140, so.
Okay. Sorry, 139.
Okay, madam, I appreciate your honesty with the court, and looking at your record, I would be very surprised if you had trouble completing a year's deferral.
Yeah, I know. I drive around all day, so I'm very careful when I drive. For work, I drive around.
And I appreciate your honesty, and I appreciate you appearing before the court.
Okay,
thank you. We'll send you information on how to make the payment, okay?
Okay, all right.
And your address is still 7112 Sacramento Street, Lakewood?
No, I told him that wasn't a current address, but I'm temporarily at another place. So,
well, for the next week, where would we mail you something?
It's 8711 Old Bird School Avenue, and Bird is spelled BYRD. So 8711 Old Bird School Avenue Southwest, apartment G301. And that's Lakewood 98499. The rest is.
Whoa, whoa, whoa.
You're fast, ma'am.
Apartment G301.
Yes. G301, 301. Yeah.
Sorry, it's a long address.
Yeah, sorry, I know.
What's the
We have
zip
real
code
boring
again?
addresses here.
98499.
Okay. I will mail your deferral notice to that address.
Okay.
Great. Thank you, ma'am. We appreciate it.
Thanks.
Have a good day.
You too.
Okay, that's
Madam
it.
Clerk, I have a quick question for you.
Sure.
If you do a deferral, do you have to pay the full price?
Yes,
That's the rule.
that's our policy, yes.
Okay, I didn't know if that, when you say our policy, you mean the policy the court has followed.
Yes.
Okay. Well, I don't see any good reason to change that. I just didn't know if it was a state law or something.
No, some courts charge a flat fee. So some courts charge $200 or $250.
Oh, charge
For the
more, in
deferral.
other words, yeah.
Right.
So the option of reducing it and deferring, unless I change the policy, would be,
Yeah, no, none of the other judges have been interested at all in
well, that makes sense to
reducing
me.
and deferring.
Yeah, I mean, it makes sense. I think it would only be, I can only picture doing it in a special case if somebody really seemed deserving or something, you know?
I would say probably look at the RCW and see what it says there.
Yeah, I will do that because I'm just curious, but
I would think
it's
Eric
not
would
something I'm
have.
itching to change or anything, so.
Okay, I would think Eric would have if.
Okay.
If
I
that
have
had been the
I have
case.
another court matter I was going to discuss with you. I'll come over there in a few minutes and discuss with you in person.
All right.
Nothing you need to worry about.
Okay.
All right. Talk to you soon.
Thank you.
Thanks.
Yep. Bye.
Hold on.
Hello.
Hello. Hi.
Is this Miss Quinones?
Yes, it is.
Okay. So, are you in compliance with your treatment right now?
I am currently out. I haven't been in treatment for a minute because I've changed providers. And so I don't know if that's, I'm trying to work out with my counselor, like what that entails exactly and what he wants to do from here. And so I'm supposed to be having an appointment with him, week after next, I believe.
Okay. So we're going to go ahead and reset your case to July 28th.
Okay.
With Judge Bates.
Okay.
And if you are in treatment at that time, just get a copy to the court so that we can present it.
Okay, will do.
Okay.
So July 28th at 12:30 again?
Correct.
Okay, cool. All right. Thank you very much.
You bet.